case briefs, and so much more. LSData's got what you're looking for.
In a 1977 case, Empire Machinery Company v. Litton Business Telephone Systems, the Arizona Court of Appeals examined a dispute over a contract for the installation of a telephone system. Empire had signed a sales agreement with Litton, which required approval and acceptance from Litton's home office. Although Litton approved the agreement, it was not signed by an officer in the home office, and Empire filed a lawsuit accusing Litton of breach of contract. The trial court ruled in favor of Litton, finding that there was no binding contract between the parties. Empire appealed the decision, arguing that Litton's conduct indicated agreement to be bound by the agreement. The appeals court had to determine whether execution of a home office acceptance clause was the exclusive means by which a contract could be made binding. In its ruling, the appeals court stated that a contract with a home office acceptance clause could still be accepted through other means if the offeree's conduct indicated agreement and was communicated by authorized individuals. The case was remanded for further proceedings to determine if Litton's actions fulfilled contractual obligations and if the involved individuals had the authority to bind Litton. The decision demonstrated that even if a contract has a specific acceptance clause, it may not always be necessary for the contract to be binding.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.